Hello learners, welcome to NEBOSH IGC tutorial, presented by 3S Life Safe Academy, a NEBOSH learning partner 1478, Bangalore, Karnataka, India. We will see, topic of, the International Labour Organizations, ILO, Convention C155 and Recommendation R164, under the NEBOSH IGC, Element 1. An introduction. Most countries has set laws and standards in the regards to management of health and safety, hazards and risks within organization, failure to enforce legal action or enforcement actions. Therefore, legal reasons for managing workplace health and safety towards the international framework and roles of national government bodies. The International Framework, ILO Convention and Recommendation. In 1981, the ILO, International Labour Organization, adopted the Occupational Safety and Health Convention, C155, which applied to all branches of economic activity and to all categories of workers, and provision should be made for occupational safety and health measures as may be necessary and practicable to give self-employed persons, workers, employees, protection analogous to that provided for in the Convention and Recommendation, R164. ILO conventions and recommendations are the basis of detailed legislation to provide basic minimum health and safety standards at workplace. We will see employers' responsibilities. As per ILO Article 16 of C155, ILO Convention, the employer has following responsibilities: to provide safe plant and equipment. Means, employers shall be required to ensure that, so far as is reasonably practicable, the workplaces, machinery, equipment and processes under their control are safe and without risk to health. Employer should ensure safe place to work. Means, employers shall be required to ensure that, so far as is reasonably practicable, the chemical, physical and biological substances and agents under their control are without risk to health when the appropriate measures of protection are taken. Employer should also ensure safe system to work. Means, employers shall be required to provide, where necessary, adequate protective clothing and protective equipment to prevent, so far as is reasonably practicable, risk of accidents or of adverse effects on health. Employer responsibility is to provide necessary training and supervision to ensure competency. Means, they must conduct training and give necessary instruction and information with respect to the specified tasks. Now we see ILO recommendation, employers' obligations. As per ILO Article 10 of R164, ILO recommendation, the employer has following obligation: A. To provide and maintain workplaces, machinery and equipment, and use work methods, which are as safe and without risk to health, as is reasonably practicable. B. To give necessary instructions and training, taking account of the functions and capacities of different categories of workers. C. To provide adequate supervision of work practices and of application and use of occupational safety and health measures. D. To institute organizational arrangements regarding occupational safety and health and the working environment, adapted to the size of the undertaking and the nature of its activities. E. To provide, without any cost to the worker, adequate personal protective clothing and equipment, which are reasonably necessary when hazards cannot be otherwise prevented or controlled. F. To ensure that work organization, particularly with respect to hours of work and rest breaks, does not adversely affect occupational safety and health. G. To take all reasonably practicable measures, with a view to eliminating excessive physical and mental fatigue. H. To undertake studies and research or otherwise keep abreast of the scientific and technical knowledge necessary to comply with the foregoing clauses. We will see now workers' responsibility. As per ILO Article 19 of C-155, ILO Convention. Following are the responsibility of the workers. A. Workers, in the course of performing their work, cooperate in the fulfillment by their employer of the obligations placed upon him. B. Representatives of workers in the undertaking cooperate with the employer in the field of occupational safety and health. C. Representatives of workers in an undertaking are given adequate information on measures taken by the employer to secure occupational safety and health, and may consult their representative organizations about such information provided they do not disclose commercial secrets. D. Workers and their representatives in the undertaking are given appropriate training in occupational safety and health. E. Workers or their representatives and, as the case may be, their representative organizations in an undertaking, in accordance with national law and practice, are enabled to inquire into, and are consulted by the employer on, all aspects of occupational safety and health associated with their work. For this purpose, technical advisors may, by mutual agreement, be brought in from outside the undertaking. F. A worker reports forthwith to his immediate supervisor any situation which he has reasonable justification to believe presents an imminent and serious danger to his life or health, until the employer has taken remedial action. If necessary, the employer cannot require workers to return to a work situation where there is continuing imminent and serious danger to life or health. We will know about workers' rights as per Article 16 of ILO R 164, ILO recommendation. Following are the responsibility of the workers. A. Take reasonable care for their own safety and that of other persons who may be affected by their acts or omissions at work. B. Comply with instructions given for their own safety and health, and those of others, and with safety and health procedures. C. Use safety devices and protective equipment correctly and do not render them inoperative. D. Report forthwith to their immediate supervisor any situation which they have reason to believe could present a hazard and which they cannot themselves correct. E. Report any accident or injury to health which arises in the course of or in connection with work. Important ILO conventions, C, and recommendations, R, in the field of occupational safety and health include C-115 Radiation Protection and R-114, 1960, C-120 Hygiene, Commerce and Offices, and R-120, 1964. C-139 Occupational Cancer and R-147, 1974. C-148 Working Environment, Air Pollution, Noise and Vibration, and R-156, 1977. C-155 Occupational Safety and Health and R-164, 1981. C-161 Occupational Health Services and R-171, 1985. C-162 Asbestos and R-172, 1986. C-167 Safety and Health in Construction and R-175, 1988. C-170 Chemicals and R-177, 1990. C-174 Prevention of Major Industrial Accidents and R-181, 1993. C-176 Safety and Health in Mines and R-176, 1995. C-184 Safety and Health in Agriculture and R-192, 2001. C-187 Promotional Framework for Occupational Safety and Health and R-197, 2006. R-97 Protection of Workers' Health Recommendation, 1953. R-102 Welfare Facilities Recommendation, 1956. R-31 List of Occupational Diseases Recommendation, 2002. The ILO Conventions, Recommendations and Codes of Practice, often use the terms practicable and reasonably practicable when describing duties or recommendations. These two terms together with absolute form a hierarchy or levels of duty which also appear in the health and safety laws of several countries. These levels of duty have particular and precise meanings. Now we will see the role of enforcement agencies. What enforcement agencies do and what happens if you don't comply. Failure to achieve ILO Convention and recommendation may lead to enforcement action by the authorities or prosecution before the courts. Enforcement prosecution can lead to a fine and penalties and, in many countries, to imprisonment for the individuals concerned. Enforcement agencies take enforcement action to ensure duty holders deal immediately with serious risks, so they prevent harm, comply with the law, are held to account if they fail in their responsibilities. Therefore, the following are the roles of enforcement agencies. Responsible for enforcing health and safety laws. Provide, advise, investigate workplace accident, take formal enforcement action for comply with law and start criminal proceeding. Fire authority enforcing the role of fire laws and fire legislation and giving advice on fire hazard. Insurance company carrying out inspection and audits for the improvement of standards. Police may be involved in enforcing health and safety law in some countries. We will see now. Types of enforcement. Types of enforcement may include providing information and advice face-to-face or in writing, serving notices on duty holders, withdrawing approvals, varying licenses, conditions or exemptions, issuing simple cautions, prosecution. They make clear to duty holders which matters are subject to enforcement and the measures they must take to achieve compliance, including time scales. We will see now the consequences of non-compliance. Breach of health and safety legislation is usually a criminal offense leading to formal enforcement action, maybe improvement or prohibition of work notices. Prosecution for organization may be fined or imprisonment. Prosecution individual, directors, managers, workers may be fined or imprisonment. Legal action against employer through civil court or legal system to prove the negligence. Claiming compensation from national or regional compensation schemes. We will see how the financial compensation of workers to be made if the employer does not comply with the duties and obligations laid down in the ILO OSH, Safety and Health at Work. Workers who become ill health or involved in accidents due to negligence can claim for indemnification, harm or loss, financial compensation, monetary benefits, remuneration, deferred compensation, salary and wages. We will see personal criminal liability and breaching the law, criminal law. Directors, board of directors, representatives might also be individually responsible in cases of gross negligence in criminal law. They may prosecuted, imprisonments, banned from the job, business. What are fines for non-compliance? Criminal liability might foresee fines for not complying with OSH legislation. The fines depend on national legislation and the systems of labor inspection, which can vary from case to case. The labor inspections can still control the fulfillment of the legal obligations and can impose fines, penalties, notices, advisory, warning, formal enforcement action, improvement notices and prohibition notices. 1. Enforcement agencies may serve an improvement notice for specify the period for compliance, and in that period the recipient of the improvement notice may lodge an appeal with the employment tribunal. 2. Enforcement agencies may serve an prohibition notice on employer, organization. The activity in question has been carried on but has been temporarily suspended as a result of an accident. Thanks for watching this video on the topic of The role of national governments and international bodies in formulating a framework for the regulation of health and safety under the NEBOSH IGC, Element 1. This video shall help you to prepare for NEBOSH IGC qualification. If you found this useful, please like, subscribe, and share. We shall soon release our video number 8 for the topic of Sources of Information on International Standards. Must watch and learn NEBOSH IGC tutorial on YouTube channel of 3S Life Safe Academy. Thanks.